Hello and welcome to Levi Salomão series of videos on Brazilian civil liability law. I'm here today to cover antitrust damages claims. As you have already seen in the first episode of the series about the basic aspects of civil liability in Brazil, civil claims must meet certain requirements in order to succeed. Basically, the existence of an unlawful conduct, the loss or harm suffered by the claimant, and causation between the conduct and that loss or harm. Claimants pursuing antitrust damages usually face substantial obstacles when bringing such claims before courts. Proving the loss or harm and the causation between such loss or harm and the anti-competitive conduct can be considerably difficult for several reasons. In Brazil, civil, administrative, and criminal proceedings may unfold irrespective of each other's outcome, which means that private claimants can file claims for damages caused by anti-competitive conducts even if a decision by the Brazilian Competition Authority is still pending. Such authorities' decisions are generally limited to the analysis of the conduct itself, without delving into the damages that may have resulted from such anti-competitive conduct. In view of that, the existence of an administrative decision issued by the Brazilian Competition Authority is not sufficient to hold the defendant liable for damages before a civil court. Also, considering that the burden of proof in antitrust damages claims is upon claimants, courts usually require appropriate evidence of causation. Indeed, it is not unusual that these claims are promptly dismissed on the grounds that claimants relied only on the competition authority's decisions, stating that an anti-competitive conduct took place, but failed to provide minimum evidence of the existence of a loss or harm and of causation. And even if the claim proceeds, proving those elements is usually difficult. Brazilian civil liability law is based on a doctrine known as appropriate causation. Claimants will typically need to produce expert evidence showing a specific and well-defined loss and a direct and meaningful correlation between that loss and the anti-competitive conduct. Finally, it is also possible that antitrust damages claims are filed by the public prosecutor or not-for-profit associations in favor of a whole group of people and companies. In other words, depending on the nature of the damages caused by the anti-competitive behavior, Brazilian law provides remedies to protect both collective interests, such as the regular functioning of the market itself on one hand, and individual rights on the other. These collective claims give rise to relevant questions on both substantive and procedural law, which may affect the outcome of those disputes. For instance, some not-for-profit organizations may not have appropriate standing to bring those claims, or the collective nature of the interests may be called into question.
Private antitrust litigation is indeed a very rich topic, and it is bound to draw even more attention. The Brazilian Antitrust Act was amended in late November 2022 to give plaintiffs even more incentives to bring those types of lawsuits. And I'll give you two quick examples. First, plaintiffs now have 5 years to bring those types of claims from the moment at which they became aware of the anti-competitive conduct. And that statute of limitations will remain told while the administrative proceedings remain pending before antitrust watchdog CADE. Second, there is a new and express rule about the so-called pass-on effects. This is a customary defense when it comes to antitrust disputes. A company that is affected by a price increase will presumably transfer its additional costs to the end consumers, and it will therefore not have suffered any losses as a result of the anti-competitive conduct. Pursuant to the Brazilian Antitrust Act as recently amended, it is defendant, not plaintiff, who will have the burden of proving any such pass-on effect. Apart from that, other changes introduced by this recent amendment to the Antitrust Act seek to promote and safeguard the Brazilian leniency program. And I'll give you one example. The basic rule is that all co-defendants must be held joint and severally liable for all damages stemming from the anti-competitive conduct. But one key provision now exempts the applicant for leniency from the joint and several liability for damages that may have been caused by other co-defendants.
That's it for now. Thanks, and please do watch the other short videos in the series. Goodbye.